Hello everyone and welcome to this video. We will be talking about what you need to know about patenting and the process involved. We'll be discussing the benefits of having a patent strategy for your business, as well as some of the pitfalls to be aware of. There'll be three of us speaking to you today, myself, Emily Teasdale, and my two colleagues, Tom Burt and Sarah Phillips. We have a lot of experience in advising businesses, both large and small, in terms of protecting their own ideas, but also navigating the intellectual property of others. If you have any questions, please do feel to email us. We'll be putting our email addresses up at the end, or you can email ai@ableimre.com. Also, please do get in touch if you wish to discuss how your company can make the most of the patent system. We offer 30-minute complimentary discussions, so do contact us to set one of those up if you'd like to. So, on to some patent basics. First of all, what is a patent? So, patents protect ideas, for example, new products and new methods of manufacture, but they are just one form of IPR, intellectual property right. Other types of IPR are trademarks. They protect company branding and logos, the classic example of the Coca-Cola logo and bottle shape that you can see here. Designed to protect the way products look. So, for example, the design of this electric shower switch. And you can have registered and unregistered design rights, the unregistered design rights occurring automatically. There is copyright, which protects the expression of ideas, writing, music, art, films, etc. Again, copyright exists automatically. There is no need to apply for copyright protection. And also there is confidential information. This includes know-how and trade secrets. So going back to patents, a patent is a 20-year monopoly right. Now this monopoly right allows you to stop others making, using, or selling your invention. Now it's really important to understand that the monopoly is really powerful because it doesn't actually require someone to copy the idea from you. They could have come up with the idea totally independently, but still be prevented from using it if you have the patent for the idea. You must apply to get a patent. Unlike copyright, it's not automatic. Once you have your granted patent, it can still be cancelled or declared unenforceable at any time. Classically, this happens when a potential infringer of the patent effectively asks for a decision that the patent was wrongly granted. Now, to give you an example, there was famous patent litigation between Hoover and Dyson. Dyson accused Hoover of patent infringement, and Hoover kind of counter-alleged that the Dyson patent, which related to the vortex technology of their bagless vacuum cleaner, they said that this patent was invalid. Now, Hoover were ultimately unsuccessful. The patent stood, and Hoover were ordered to pay £6 million in infringement damages and legal costs to Dyson. Patents are territorial. So a UK patent, for example, allows you to stop others using, selling, and making your invention in the UK. And it also stops anyone importing products falling in on the scope of your protection from importing them into the UK. But it doesn't provide you with any protection in any other countries. Generally, for UK clients, what we tend to do is we first file a UK application, and then any other applications that you might like, we file within the first 12 months of that first UK filing date. So this leads to an important question about how do you go about deciding which countries you want patent protection in. You need to bear in mind that you want to achieve effective protection, but patents can be expensive and you don't want to get lots of countries that aren't giving you value for money. So some questions you might want to think about when trying to answer this question are where your competitors, potential collaborators are, where their markets are, where might you be able to license the technology to get some revenue that way, and where might it be likely to be manufactured. With all this, it's worth bearing in mind that even big companies don't tend to file in lots and lots of different countries, perhaps with the exception of pharmaceuticals. Quite often Europe, the US and China is a good balance between the amount of coverage that you would ideally like and the cost. The last point on this slide is that patents are published. They're published after 18 months. And so at this point, all the information in them becomes public. Now, this is the trade-off. So you get your monopoly for your idea for 20 years, but you do need to disclose your idea in sufficient detail so that once your monopoly is over, people can fully work the invention. So we've talked a little bit about patents. What ideas can you get patent protection for? So to be patentable, an idea must be new. So the invention that you come up with must not have been made public anywhere in the world at the time that that first patent application is filed. And Sarah will be talking a bit later about some of the pitfalls to be aware of with this issue. The second thing is that your idea needs to be inventive. It needs to involve an inventive step over what is already known. This means that it must be unobvious to a skilled and knowledgeable person, but that person who doesn't have much imagination, or in fact any real imagination in that field. So this leads to the point that you can get patent protection for incremental and evolutionary improvements. You don't need to come up with something entirely revolutionary in order to get patent protection. In my experience, engineers may well think that something they've come up with is obvious, because I think they underestimate kind of the cleverness of what they've come up with. What I would say is if your idea is new and it has a commercial advantage, the chances are that you would actually be able to get patent protection for it, and that protection could be really quite valuable in putting yourself ahead of your competitors. I would say think of this hurdle as needing an inventive step rather than an inventive leap. I'll give you a couple of examples of ideas that I've secured granted protection for my clients, just to give you an idea of how inventive you need to be. So the first example, on a vessel for laying pipeline, there are clamp arrangements for clamping the new pipe string, which is to be welded to the pipeline that's already being laid. Now, the difference here that our client came up with was that pipe string clamp was able to rotate the pipe string about its longitudinal axis, and this hadn't been done before. The advantage of this is it enabled the pipe string to be rotated to better match up its end profile with the profile of the pipeline it was being joined to, and we were able to secure patent protection for that. A second example for you, on an aircraft seat table, this table was provided with a phone or a tablet holder. And the key difference here was that our invention had a number of different ridges for propping up the device at different angles. Now, this meant that the holder could be used to hold lots of different sized devices. And again, we were able to convince patent offices that this was inventive enough for protection. One other thing I'll just add here is that even if you are ultimately unsuccessful in persuading a patent office that your invention is in fact inventive, you would have then by that point had a patent pending for a number of years, which can also be incredibly valuable in keeping your competitors off the market in that time. A third hurdle here is being useful in industry. I won't say any more about this because it's not normally a hurdle, but it is something just to bear in mind. And then the fourth one is not to be in an excluded category. Now, the boundaries of what is patentable is the source of many disputes, and Tom will be discussing these next. So these four issues are decided during examination of the patent application. Now, during this examination process, you can amend your application, for example, to limit the scope of your monopoly. So if you filed a patent application for a broad idea and you realised that there was a document that meant that that broad idea wasn't new, you could limit your scope to something that was new and was inventive. What's important to note here is that you can only amend your patent application to include features or combinations of features that are already included in the patent specification. You can't add any new subject matter in there. So this is a reason why it's really important to get your patent specification drafted in the right way before you start. And once all of the patent examiner's issues have been addressed, the application will then proceed to grant. I'm now going to pass over to Tom to talk about the exclusions from patentability?
Thanks, Emily. Yes, so I'm going to talk about what can be protected using patents and some of the areas that can be difficult, especially the exclusions from patentability. So as you may well know, a patent has at the end of it a set of claims, and they define the protection given, so by defining the invention in terms of sets of features. So what might you have as claims? You might have a claim to products, devices, systems. So to just give one example, you might have a particularly inventive gearbox. Sometimes patents, inventions can also fall into component parts. So you might have a lock and a key, both of which embody the invention, or a client and a server, or a transmitter and receiver. You could have separate claims to those as they both embody the invention, but just in different forms. Another possibility is process methods and uses. So it might be a manufacturing process, or it might just be the way a device operates or how the device is used. So you may have in one application, in one patent, you may have claims to the product, but also claims to the method of how the product operates. So getting your protection in two ways. And one thing to note is by having method claims and process claims, you can also get protection to the direct product of a process. And as a final type, there's various other miscellaneous types of claims you can have. So a kit of parts, a computer program, which when run embodies the invention, a chemical precursor in a chemical process, or a larger system. So for a gearbox, that might be, for example, a car incorporating your gearbox. So some of the difficult areas. Methods of medical treatment is one. You can't patent, in Europe at least, methods of surgery, therapy, or diagnostic methods. That doesn't mean you can't get any protection in these areas. It just means you need to be careful about how you try to protect them. So you can protect surgical tools or diagnostic tools and that kind of thing. You just need to be careful that you're claiming them in the right way. One particular example is the what's called a second medical use claim. This comes from the realization that it's very useful. The discovery that you can use an existing medicine to treat a new disease is very useful. So you're allowed to have claims in the form of use of medicine X to treat condition Y. Another area is plant and animal varieties, and essentially biological processes for the production of plants and animals. They can't be protected, or not always protected. Microbiological processes and the human body and gene sequences are other areas where you need to be careful. So in all of these areas, it's not to say you can't protect these things. You may well be able to protect them as long as you take care in how you try to do so. So for gene sequences, you can protect as long as it's been identified that they have a particular effect. And there may be other sorts of IP which can be used to protect them. For example, plant varieties can be registered. But in all these cases, it's an area to be careful. And the final area is the invention is contrary to order, public, or morality. Now, this is not something that comes up very much at all, but the idea is if you have an invention which is genuinely abhorrent, so for example, an improved letter bomb is an example that's sometimes given, you shouldn't be able to protect those using patents. Software is a particularly tricky area because the law is complicated. So copyright is usually used to protect software because it arises automatically. So it's very easy to get, it's just automatically there. But the problems with it are that it only protects copying, so not independent creation, and it only covers the software code, not the underlying ideas implemented by that code. So if someone comes along and writes their own code to give the same functionality as your software, chances are you'll won't be able to do anything about that using copyright alone. So can software be patented? Yes, it definitely can be. The law is unclear on this. Sounds on face value is unclear on this, and you often hear people saying that it can't be, but it's not true. It's definitely possible to protect software. Thousands of software patents are granted each year, and it generally gives much stronger protection than copyright because you don't need copying, and it copies and it protects the underlying ideas and not just the way the software code is written. There are other requirements that are required on top of the usual ones though. In Europe, your invention needs to be considered technical. In the USA, it needs to be not abstract. So what do they mean? It ends up being a bit of an elephant test in the sense that you know it when you see it. What I would say is feel very free to give us a call if you've got a software related invention and you're not sure if you can protect it or not, because it may well be something you can't work out from first principles. We will be very easily able to tell you whether it's the kind of thing which may be difficult or whether it's going to be fine. And so you should consider going ahead and patenting it. To give some examples of what can and can't be patented in the software realm. So control software for a drone to make it more stable in flight, that's definitely considered to be a technical problem, so you should have no problems protecting that. Inventions at the level of computer architecture, so something that makes a computer more efficient, more reliable, and more secure, or uses less data or uses data more efficiently, that's going to be considered technical and shouldn't be any problem. And generally things in security or encryption area considered to be nice, hard technical problems and not difficult to protect with patents, as long as you do it correctly. On the other side, financial processes can be very difficult to protect, quite possibly, maybe impossible. That's because they're considered to solve a financial problem rather than a technical problem. But if you're talking something, if you have something like a more secure banking application, there may well be technical inventions in how it stays confidential, how it passes messages back and forth, how it avoids being hacked, all that kind of thing. So just because you're in the financial realm, it doesn't mean there's nothing you can protect. Methods of pure calculation can be difficult as well. They're considered to be too abstract if they're on their own. So for example, a method of determining the length and size of triangles probably be considered too abstract on its own. But if you were implementing this in a graphics card in order to more efficiently show graphics, generate graphics on a computer system, that's going to be considered technical, and that certainly you should be able to protect using patents. And another area is displays of information. There's a specific exclusion in European law for presentations of information. They're not considered to be patentable. But you may well have things around how the data is stored or how it's extracted for display. And that way you may well be able to protect that because it's considered technical in the way that you're managing the data and not simply the display that you're making.
Thank you, Tom. So we've talked about the patenting process, but what is the value of a patent application and later a granted patent? Well, we've said before, fundamentally, they protect your technology so that others cannot sell or make products or use processes that take advantage of your new ideas. Now, this could give you a few things. It may mean that you're able to sell your products, including the new features, at a higher price, as your competitors can't simply copy those features. It could mean that a customer is tied in to obtaining products of a certain specification from you, even if a contract with you has come to an end. It's also advisable to file a patent application prior to entering into any kind of collaboration or joint venture. This is because it puts a line in the sand as to what are your ideas and what are the joint ideas. To give you an example, a client of mine filed for patent protection for their initial project ideas prior to discussing them with a collaborator. This has then put them in a very strong position, and they're able to control the market and prevent their collaborator entering that market without them after that venture came to an end. Having a patent portfolio that disrupts the plans of others can put you in a strong bargaining position. So, for example, if you realise that you want to use a third party's technology and they have protection for it, you might be able to get a cross-license with them at a much more favourable royalty rate because you have your own patent yourself that they might want to use. You can license out your technology or, in fact, sell the patent itself. And this way you can get a revenue stream without even having to work the invention yourself. Having a patent application or a granted patent can attract investment. And the final one I want to touch on is the patent box tax regime. This provides a lower corporation tax of 10% on profits related to a patented process or product. Now, for some of our clients, the savings that they make through this tax regime have paid for the cost of patenting on their own. So now I'm going to pass over to Sarah. As promised, she's going to be talking about some of the pitfalls to bear in mind.
Thanks, Emily. So we've just heard about some of the benefits of filing patents, and now I'm going to cover some common pitfalls in the patenting process. Now, these are all areas where things can go wrong if not dealt with properly, but if you are aware of the issues early on, then it's very possible and straightforward to get things right. The first pitfall is ownership. It's important that you do actually own the rights in the invention that you want to file a patent application for. In patent law, the rights in the invention originate with the inventors. These are those people who have devised the inventions that contributed materially to the invention. If the inventors are employed, then usually those rights pass automatically via patent law to the employer. Rights in the invention can also pass between parties by an assignment of the rights. So the challenge is to make sure that the legal chain of title properly reflects what has been agreed commercially between the parties involved. In a straightforward situation, for example, if the inventors are employed by your company, the rights pass automatically to the company, as I've just described, and you can file the patent application in the company name without any real difficulty. However, if you imagine another situation, let's say you've won a contract for a piece of work, you've overcome some technical problems, and to protect your innovation, you file a patent application. You've checked that the inventors are all employees of the company, and you filed the application in the company name, so everything seems okay. However, later on, the organisation that originally tendered for the work says that they paid for the work and actually the patent should be theirs. So what do? Well, now you're not in a great place, you're in a dispute, and the situation will need to be reviewed very carefully and unpicked to see what can be done next. It's much better to have, firstly, consensus amongst the various parties at the outset regarding in whose name the patent application will be filed, and secondly, agreements in writing that set this out. It's worth keeping in mind that even if you do have commercial agreements drawn up, it can still sometimes be necessary for us to prepare assignments to make sure that the rights pass via patent law to the correct party. When you are doing all of this, one thing to aim for is to try to have the patent application filed in a sole name rather than joint names. In most jurisdictions, there are some restrictions on what one co-owner can do without the consent of the others. An example of this would be making amendments to the specification. So even if the parties are on good terms, needing consent can really slow things down. It's generally better to have one party with autonomy who can make decisions. And then if another company needs to work the invention, then a license can be set up under the patent to give those rights. This brings me on to my second pitfall, which is disclosure. We've already heard from Emily about an invention needing to be novel to qualify for patent protection. Now, this means that the invention must not have been disclosed outside of a confidentiality agreement anywhere in the world in any form. So this includes as a printed publication, it includes on the internet, it includes as a presentation, it includes a demonstration at a trade fair, and it even includes an informal conversation over coffee. Other people's disclosures can count against you, and this situation would be one of independent development of the same idea. There's not much you can do other than trying to file your application before this disclosure comes into the public domain. And if you can't foresee that, then all you can do is don't leave it too long before you file. But more commonly, actually, we find that disclosures, your own disclosures, can count against you accidentally. And once the invention is in the public domain, your options are then very limited. So if an academic paper is going to disclose your invention, then do make sure you file your patent application first. If you are going to be providing a sample to a potential investor, then again, make sure you file the patent application first. Similarly, if you are going to be entering into discussions with a potential customer, again, make sure you file your patent application first or have a suitable non-disclosure agreement in place. Just because you are assuming that your discussions are confidential doesn't necessarily mean that the other party will do the same. It really is good practice to have these agreements in writing. It's a good idea to have non-disclosure agreements in place with anyone that you're going to be communicating with about the invention. And as a final point on disclosure, I would say generally try to minimise the conversations that you have until the patent application is filed. It's much better to have them afterwards if at all possible. So this brings me on to the third pitfall, which is freedom to operate. This is a really important concept, commonly misunderstood. So there's a common misunderstanding that having a patent gives you the right to use the invention, and that's just not correct. A patent gives an exclusive right which enables you to stop other people from working your invention. So it provides this monopoly, as Emily's already described, for a defined period of time. So this means that equally for you, your commercialisation of your invention depends on any patent rights that are held by other people. Now, to give an example, we can look at the car here. So let's say that you've come up with the invention of the car. It's very clever, hasn't been done before, and you get a patent granted for it. You then want to make your car, but actually you find that you can't because somebody else already has a patent for the wheel. This is a really important concept which needs to be kept in mind. So what can you do? If we then move on to my next slide. Well, you can search for competitor rights in your particular field, and we can help you with that. Once you know what's out there, then you will have options for responding in the best way for your business. So you could, for example, design around the patents that are out there. You can change your product, modify the scope slightly so that you're working around the patents that are out there. You could approach the third-party companies. You could try and have an amicable situation where you take a license under their patents. As Emily's already mentioned, there is a cross-licensing option there as well for a more favourable royalty rate. You could even take more aggressive action and you could seek revocation of the patents. You could attack them. Or you might decide to postpone your project. You might decide to move to a territory where there is no patent protection so as to work around your competitors' patents. But the key thing is to just understand that it's an issue and decide what you want to do. So are you going to invest up front in searching for competitors' rights, or are you confident that you know the industry and you know what your competitors are doing and what patents they hold already? That's up to you. So 2 key messages to take away. Firstly, don't disclose your invention prior to filing your patent application unless you have a confidentiality agreement set up. And secondly, consider patentability and freedom to operate as separate concepts and make sure that you give proper consideration to both.
Thanks, Sarah. So we hope the information here has been helpful to you in thinking about how your company can leverage the patent system to your advantage. Like I said before, please feel free to contact with us by email. Our email addresses are up on the screen now. Let us know if you've had any other questions, if you wish to subscribe to our newsletter, or you'd like to talk about any of this in more detail. Thank you for listening, and we hope to hear from you soon. Goodbye.